Does it? I have to answer this. So I witnessed. Can you be here?
I have no problem with that.
Okay, we're on record. Well, welcome to Sayreville Municipal Court, approximately noon. We're here on the matter of Steve versus Matthew Dolitsky. Am I pronouncing that right?
Yes.
Okay. And we're ready to proceed on a trial. Mr. Dolitsky with you? Or
Yeah, I'm right here.
Okay. So let me go through it first with regard to it, and then counsel for the record, starting with the state.
John Krenzel, appearing on behalf of the state.
For Mr. Dolitsky, Jacob Uriel, Uriel.
G-R-U.
No, Uriel.
Okay, so we're ready to proceed. What I have is one criminal charge, 1219-2025-000238, a charge for 2C18-CB2, which is out of trespass. And also a few other charges to trespass on borough ordinance, the other topic 13.1, 13.2A, and 13.2B. So that's what we're proceeding on.
And Judge, my application, again, just for the record, is that we can't go forward on the all three of the municipal violations because the 13.2 D and A are simply a statute that define conduct that is otherwise prescribed by 5-13.1. So they definitely merge in that respect. There's, so I think, they could have two theories, the A and the D, but it doesn't add up to three.
And we'll take it under notice. I'll make a decision once I listen to the testimony in this particular case. Again, what you're saying is one defines it, and one is just the statute.
Correct.
I'll take that into consideration when I review it and listen to the testimony and the evidence in this case.
Thank you, Judge. Can we just step up for one brief moment?
I'm just going to take one short recess.
Okay. Have a seat, please. It's Creston, Core Valley.
Kirsten, Court Valley. Kirsten, like her.
Mr. Krenzel?
Court
Mr.
Valley.
Krenzel, what do we do about James Pickering? Is that adjourned?
Yes, Your Honor. The attorney just popped in, and at this point, I can't handle it, so I requested adjournment.
Mr. James Pickering,
His attorney is here.
did you ask out in the hallway James Pickering and his attorney, which would be Jeffrey Farmer?
No, Your Honor, it's only up.
W, not
Right, back on the record, this is on the case of State versus Matthew Dolitsky. The charges with regard to it will be introduced to the attorney. Just for the record, the access for video and audio has been granted by the courts, and so we have other journalists in the courtroom. So we'll proceed now. Anybody have any particular housekeeping events? Or should we start with proceedings?
If I may state, their defense has a witness. We have no objections to the witness sitting here. Does not have to be sit outside.
No sequestration orders requested. Okay. So do you have an opening or wish to go ahead with it?
As simply that, as Your Honor has stated, this is a trespassing matter concerning property that is on the South River. There is a video which both sides have agreed that will be presented in a few minutes after the complainant gives some foundational testimony.
Any opening for you, Mr. Uriel?
Judge, we're not going to belabor what I think the evidence very clearly show is that the conduct and the facts and circumstances here simply do not amount to a violation of either the, I would argue, two municipal ordinances nor the criminal justice code violation.
Request the complainant be sworn in.
Please stand. Would you please rise? Your name for the record, please spell it.
Kirsten Courtbowie, Kersten, Courtbowie, K-O-R-T as in Tom, B as in boy, A-W-I.
So I'm just going to tell you the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
Okay, you can be seated and stand whatever you're more comfortable.
Thank you.
And your witness.
All right, let us begin. First of all, who are you in all of this?
Again, my name is Kirsten Courtbowie, the complainant. I own the property upon which the defendant trespassed, which is
Objection.
which is located.
Objection.
She's making a legal conclusion. She's not described. She's testifying as to her conclusion as to trespass.
Oh, no, she's just making a statement as to who she is.
That's correct. It's,
Go ahead.
go on.
Thank you. The property, the street address is located at 222 Journey Mill Road in Sayreville, New Jersey.
Okay. Do you have authority to file the complaint in this matter?
I do. I own the property through an LLC, Viking Terminal Holdings LLC.
Okay.
I'm sorry, what was the name?
Viking Terminal Holdings LLC.
Go ahead.
You are the sole owner of the LLC?
At the time that I filed the complaint and at the time of the trespassing, yes, I was the sole owner.
You are stating that there has been a trespass. How do you know that there has been a trespass?
I have observed a video that was posted to YouTube by the defendant, which depicts him boarding my private dock, entering my property, and boarding a boat that my family owns. It's on a creek in the property.
Is the man sitting to the next of the defense counsel the man that you're accusing of trespass?
Yes, he appears to be the same man that's in the video.
The record reflects that an identification has been made of Mr. Dillitz.
Judge, I would note that this is not an actual identification because it's not based on anything she observed. There's different standards for, she's basically saying, well, who I saw in the video is the same person here, but she's not able to actually identify anybody she saw in real life, and I think that she's not then qualified to make that identification. The video will speak for itself.
I'm going to deny her request. I think she saw the video. She's been able to observe it. She's been able to see the client team in court. She's making an observation of the same person that she saw in the video is here, so I'll allow that.
How did you find out about this video?
So the property is a commercial property that we rent out to various tenants, and one of our tenants informed my husband and I about the existence of the video that was posted on YouTube.
Did you watch the video on YouTube?
I did.
Okay. Well, then, before we go any further, Your Honor, with the consent of the defense, I present to the State Exhibit 1 a flash drive of the video.
We refer to it as S1, which is the flash drive of the video. You want to just explain a little bit more, or you can ask your client what the video will show?
Would you explain what the video is going to show?
Yes, Your Honor. The video is a screen capture that I took of the YouTube video that I referenced earlier. It was posted on November 13th, 2024, and it's about 36 minutes long and was posted on the defendant's YouTube channel.
And you've seen this, Mr. Uriel, is that right?
I have.
And you wish to display this now?
Yes, Your Honor. Before we do that, though, did you make any changes at all to this video?
No, again, it was, I did not download the video from YouTube. I played the video on my laptop and I took a screen capture of what was depicted on my laptop.
Then, if we may.
This is S1, which is a video of what she's referring to as to what her attention. Go ahead.
I have to crawl again through this section. Holy cow. I made it up. We're on the boat. Why do you think it's here? How did it get here? Whose boat is it? Hey guys, this is Matt with 2 Feet Outdoors YouTube channel. Today, I'm at the South River in New Jersey, and I'm headed out kayaking to an abandoned ship. It's a beautiful day, and it's gonna be an amazing adventure. All right, let's go ahead and get this kayak set up. Guys, this abandoned ship is literally in one of the most unlikely places that you'd find an abandoned ship. This is going to be such a unique adventure. I've been wanting to come here for a really long time, and hopefully today we can get to this ship, climb aboard it, and check the entire thing out. All right, and we're paddling. All right, guys, so like I said, we are on the South River in northern New Jersey, and we are kayaking out to an abandoned ship. The ship is in a really tight canal, like amongst the marshland. It's so out of place, and we're gonna see if we can find it. One problem that we have right now at this moment is that it is currently low tide. So I have a feeling we're gonna need a little bit more water to get to this boat. I think it may be sitting high and dry currently because it's low tide. So we'll see when we get there. But I really think this is gonna be incredible. I am looking forward to it. I've been wanting to do this for such a long time. It's pretty industrial surrounding this area, and the spot I launched is actually private property, but I did get permission from the property owner to launch my kayak there. I did go to a park not far from here, and it's basically mud flats all along the shoreline, and with it being low tide, it's just straight up mud if I was going to try to launch my kayak there. So this definitely helped out a bit. You know, somebody in the comments mentioned that I should do a catch and cook type situation in one of my videos. But I hate to say it, but all the places that I kayak, I really do not think that I want to catch a fish in any of these waters and try to eat it. I just don't trust it. All these waters that I kayak have some level of pollution, and you know, the fish are living in the pollution. So yeah, I definitely don't trust it. Oh, we have a little dock up here to the left. And the sheet piling on the seawall looks like it's collapsing. But I believe we're getting close. I don't have my phone out, so I'm not looking at a map. But I'm keeping an eye out for. There's a few different offshoots. Like I can see one to the right. I know it's not on that shore bank, so it could be up here. I am concerned about it being low tide still. We still have a ways for that water to come up. I'm keeping an eye out to the left. You know, maybe there's a narrow creek or something we can paddle in to make our way to it. If it's there. Holy cow. There it is. Wow. Wow, it's down this creek. I can see it way off in the distance there, but I don't know if we can get through this narrow chute here. I'm gonna push a little through here, but like this mud, look at this, holy cow, to the right. This is just thick, nasty mud. Oh, yep, we just stopped. Look at this, nasty. So there's no way we're gonna be able to, it's like bubbling. Wow. My paddle is covered in muck. I'm just paddling back out, backwards. Two things. I don't know if we can access the ship somehow, some way through this dock, or if we're gonna have to wait for high tide. I can't even get this mud off my paddle. I'm gonna get out my other camera and get a closer shot of the ship down in that creek. All right, so that was really cool that we spotted it. Now I have to figure out how to get to it. That dock that we passed, it's up here now. There's no sign saying private property, no trespassing, nothing of that sort. So I may pull up onto the dock and investigate and check it out a little bit further. But yeah, I don't know. That ship is surrounded by tall seagrass. But since we're waiting for the tide to come up, we might as well go check this out. Yeah, there's no signs, nothing over here. You know, I don't even know if it's gonna help us out or not, but we'll take a look. All right, I got the kayak pulled out of the water, and we're gonna go up this walkway here and see what this leads to. It looks very quiet. I see a boarded up structure to the right. Just a couple tractor trailers. All right, I think I found what looks like a trail. I have no idea. Just gonna take it for a bit. See if it leads to where we want to go. I don't like how noisy the leaves are. Oh, there's seagrass here. Can't see a ship on the other side of it yet. I don't know if you guys can see it, but right there, that's the smokestack. I need to go back and see if I can secure my kayak. I just don't want somebody to come to the dock and see it there. We're gonna keep going through here. All right, guys, I've been bushwhacking, and look at this right here. You can see the ship. But here's the little trail, but it's heavily overgrown. I'm gonna have to go on my hands and knees through here. You can see there's a big tree branch above me. You can see we're getting closer to the boat, but it's really muddy. Look at this. You can see it much better. All right, this is a mess, guys, but we're doing it. You can see down here, it's just like in the mud. There's no water around this ship right now. And I have a feeling if I step down there, I'm gonna sink. But right over here is a ledge. I think if I can get something over here that I can stand on, I might be able to prop myself up to get on this boat. All right, I'm gonna try to reach and see what this door is like, if it's secure and I can put some weight on it. I think it is. I'm gonna move my gear over here. think I can put my weight on that door and pull myself up. All right, there's no footholds really. I could put a knee over here. Okay. Holy cow. I made it up. We're on the boat. All right, guys. I am gonna walk slowly on this boat to see if we can get to the upper deck, so you can kind of get some perspective. It's got a wooden deck. Looks to be pretty strong though. Just gonna walk to the front of the deck. Wow, you can see there's no water down there. Look at this right here. It's like a winch for the anchor. I'm just trying to get a feeling for the boat to start with, and then we're gonna look a little closer. Wow, this is like the main cabin, you know, where there's the helm, where you'd steer the boat. Let's see where this door goes. We have some stairs. Whoa! Floor sounded like it cracked. I'm gonna go back. Oh, we can't go outside here. You can see on the other side there's actually a ladder that somebody has to get up here, but this is much higher. I think it was easier to get where we went. I need to try to figure out how to get to the front of the boat and to the top of the boat. There's a bathroom right here. You can see a sink. Down in these stairs, looks like it's just caked with mud in the bottom of the boat. Looks like another bathroom. We have a sink over here. Oh, check it out. Telephone, so cool. I gotta try not to fall through this floor. Here's some light switches. Stern light, master headlight, bow lights. Pretty cool. Let's see what's under here. It's like a steering mechanism, steering gear, hydraulic steering gear, and the steering wheel was right there. Dashboard kind of situation. Okay, here we go. I found the stairs, but at the base of the stairs, I don't like this right here. There's a hole in the floor. We're going to try to move this and get right up onto a stair. Just climbing up these stairs. Wow. Just gonna walk lightly here. Not that that's gonna make a difference. If it's gonna break and I'm gonna fall in, it's gonna break. But look at this. Holy cow. I can't believe it. Can't believe we're here. Look at this. This is like a mast that you can raise and lower. And then this looks like another set of stairs down to the front of the boat. We're going to go down there in a minute. But yeah, let's go back over here. I just saw a truck in the adjoining property, so I just ducking down. I think we're good. I'm sure nobody has a clue that I'm over here. There's that truck again. All right, I'm going to go down the stairs to the front of the boat. I'm going to go down them backwards for safety. Wow. This is so cool. The deck, I'm telling you, the deck is solid. All right, so this is the back of the boat. Seating areas. That's the creek that we needed to paddle in on. Looks like the tide's coming in just a bit, but that would have been difficult. Check out these huge cleats. Let's check these doors. This is all tore up. Looks like the ceiling collapsed. You can see like some speakers, like an entertainment area where my light's shining. But this is a mess. I really don't want to walk on it or walk across it. I don't know what's underneath. All right, let's go back up. Stairs feel strong. But you can see, guys, this ship is just tucked right in here. There is no room on either side of this creek. Just look at this side. Radar unit. It's a big horn right there. Let's see what this is. Just looks like a little storage. More storage on this side. All right, I'm going back down here. But again, I'm going to turn around and go backwards. I'm going to hold on. And I need to remember that there's no floor at the bottom. I need to find something to hold on to. We made it. You can see right here, that's where we crawled in and came up here through this door. This looks like a machine room. It has it definitely looks like engines down there. So yeah, it's like the engine room. And there's a set of stairs right here. You know what? This railing and stairs seem very strong. And I'm going to take it really slow. And we're going to go down these stairs just a little bit so we can see down in here. I'm just going backwards. I'm right at the bottom step before you hit the water. Yeah. We're in the machine room right now. Looking all the way around. Wow. All right, let's go back up. That was sketchy enough. I think I forgot to mention it, but I did go back and kind of secured my kayak better, so it wasn't just sitting on the dock. I actually kind of hid it, so if somebody came in that area, they wouldn't find it. All right, we're back to the front of the boat. I'm just completely in awe, guys. This is so incredible. You know, why do you think it's here? How did it get here? Whose boat is it? So many unanswered questions. But look at this. See what that is. Some electrical box. Light switches. Oh, look at this. thermostat. That was cool. We pretty much explored this entire boat that we could safely explore. And what I'm going to do is trek back through the woods, and then looks like the tide's coming up. We're going to try to put the kayak back in the water and kayak up into this creek. All right, I'm going to try to see if I can get down the side of this ship without busting my butt. I'm going to hold this part, and we're going to drop. Oh, made it. All right, trying to get back to the shoreline here. It's very slippery, very, very slippery. I don't want to bust my butt and land in the mud. I have to crawl again through this section. All right, I think I can stand up a little bit. Here's some of the open area. Less bushwhacking right here, but we're going to get to some more sticker bushes, bushwhacking straight through here. There's really no actual trail. I'm just trying to take the path of least resistance, squatting down because the trees are hanging over. All right, we're almost back to the clearing. All right, guys, I'm back to the dock. I think we're in the clear. I'm gonna walk down here, sit my gear down, and then grab the kayak. All right, I'm gonna go back up here and get my kayak from the hiding spot. What a beautiful evening it is. All right, I'm going to put this thing in the water and we're going to try to go down the canal. All right, we are back on the water and I am paddling around to the creek where this ship is, and hopefully the tide has come up enough that we can paddle in there and just see it from the water level. I am filthy, guys. My hands, my arms, my legs. I am covered in dirt and mud. But it was so worth it. Oh my gosh, that was so incredible. I just hope we can paddle in here and see this thing from the front. The boat was actually brought in there front first, so when we go in, we're actually going to see it from behind. But it definitely looks like the water level has come way up, and we're going to take it slow. There it is, straight ahead. Wow. This has been such a fun trip. I'm just creeping up to it nice and slow. I don't know what's underneath me. Just want to make sure there's enough water. Wow. But yeah, this is the way when we were up top and we saw the ladder. This is the side the ladder was on. I'm just gonna back up here. It looks like more water fills in on this side first. And we came in on this side. I don't know if you could see that open door over there. That's where we went in and out. Oh, this mud is thick. We are in some serious murky water, just leaving an abandoned ship. And we have just this incredible sunset. All right, guys, all I have left to do is paddle back to where we launched from. So I want to take this moment here to thank you guys for watching 2 Feet Outdoors YouTube channel. If you guys like these videos and aren't subscribed to the channel, please subscribe to the channel. It really helps me out a lot. I'm trying to grow the channel, and I'm gonna keep bringing the best content to you guys that I can. I love trying to be creative. I love kayaking, backpacking, camping, everything outdoors. So thank you guys once again for watching 2 Feet Outdoors YouTube channel. We will see you on the next one.
We're going to conclude the video. It's roughly 36 minutes long. Okay. You moved into evidence. Any objection?
No objection.
Please, Your Honor.
That's one you moved into evidence.
I show you a picture for identification. Can you tell me what this is?
Yes, this is an aerial photo of my property, and it has a black outline delineating the property line.
Defense counsel has seen this.
I am going to consent, but very brief voir dire on that.
Please.
So the property line, did you draw that, or was that, who drew the line on that image?
This image is captioned as a site features map from a remedial action report prepared by Arcadis. And as I understand it, Arcadis drew the property line on this map, and it's consistent with the Sayreville tax map.
Okay, no objection.
S2, which is the aerial photo of the property, will be submitted into evidence as S2.
The defense and the prosecution have copies of this. Just briefly to orientate ourselves. On this S2, can you point out where is the boat?
Certainly. Looking at the black line that demarcates the property line, the boat is located in the creek, which comes off the South River in the lower right-hand corner of the property. You can see a long white object, and that depicts this boat.
Okay. Is the South River Boat Club indicated on this photograph?
So it is visible. If you look on the left-hand side in the middle, you can see docks that protrude into the South River and a white outline, which is consistent with my understanding of the South River Boat Club.
After you saw this video, what did you do?
I watched it a couple times, and I made notes of various statements and actions by Mr. Delitsky in the video, and I made efforts to determine when the video would have been taken based on when it was posted on YouTube, and some other features that were indicated in the video, and then I proceeded to obtain a police report about the trespassing.
Okay. Is Mr. Delitsky licensed or privileged to go upon this property?
Absolutely not.
Okay. The property is not open to the public?
Correct. It is private property and has been so since my parents bought it in the 1970s.
Okay. From what you've seen, did he enter onto the property?
Yes.
Okay, then. Is there any notice against trespassing on the property?
Well, along the river, there is a sign that says "No wake, no trespassing." That's located on the bulkhead adjacent to the private dock that Mr. Delitsky entered the property from. Along the street at the main gate, there is an 8 by 10 foot sign with 21-inch letters that says "No trespassing." And there are numerous other no trespassing signs around the periphery and inside the property as well.
Objection.
What's the objection?
She's saying there's numerous other signs inside the property. Like, there's no discovery on that. There's no, we did request, and whatever signs are inside the property aren't really relevant to signs outside the property when he's accused of entering the property. So, she's talking about multiple signs, and that's very vague.
Deny your application for him?
Okay. In the video, does he pass this sign that you have referred to?
Yes, so he passes the no trespassing sign at 4 minutes and 24 seconds into the video. He passes it on his kayak, and I just noticed it in his closing shot. You can also see the no trespassing sign behind him as he kayaks back towards the South River Boat Club from my dock.
Okay.
What color is the sign?
It's yellow with black letters.
Oh, that's irrelevant. And again, he had no permission to go aboard to be on your property?
Absolutely not. And I'd also like to add about the sign that I just spoke about.
Objection, not responsive.
It's been there for 30 years, and it's worked for 30 years.
Objection, Judge.
Okay.
What's the objection?
She's talking about how the sign has worked. That's not relevant to the question at hand in this case. She's basically editorializing. She's not testifying anymore.
It's not insufficient, but it'll go to the sufficiency of what she's talking about, but go ahead.
Do you have any other, does this sign that is sitting up there, does it work?
It does, and I'm only aware of one other instance of someone trying to enter our property from the waterway. It would have happened in the 1990s when another person tried to board the boat when it was docked on the dock, and my parents filed trespassing charges, and that person was.
We'll submit there. I mean, it's, that's going too far. It just,
With regard to it, but
Yeah.
it's not proper, but it's just not relevant.
okay,
Well, that's the objection. It's not relevant.
Granted that.
okay. Is there anything else you want to add to this?
I mean, I can add in some of his quotes from the video, so it's on the record. Just to reiterate, the fact that he had the kayak and I think I'm in the clear. All these things to show that he was supposed to be there. So everything I've highlighted in pink is what I will state in.
I don't know if he's going to allow that. We'll try. Okay. Because it speaks for itself. All right.
Can you just ask me about some of the things that you started with?
Okay.
Next question.
We talked about before that he had no license or privilege to enter onto the property. In the video, is there anything in there that states that he had no, that he knew that he did not belong on the property?
Yes, there are many instances during the video and many comments from Mr. Dolitsky which indicate that he was aware that he did not have license or permission to be on the property.
What's the objection?
Judge, she's basically giving her opinion on what he said in the video. So I would object to that because it's not really fair for her to characterize the video. The video speaks for itself. So, and it's not really responsive to the question.
Do you have any comment?
It's a statement as to bring onto the record, showing his intent as to what he was doing at the time. Yes, the video does speak for itself, but it's also to present to the court to show the various spots in the video, which I'm going to make reference to anyway at my closing, as to what his intent was.
His closing is his closing. She shouldn't have an opportunity to start talking about his subjective intent based on comments that, and I think we can all agree, don't actually say anything, right? These are her arguments that she's making, and she's not qualified to make those arguments as a witness.
It's not subjective, it's objective. It's what it's on the video.
In allow her testimony, you have the ability to go through cross-examination. She's not giving an opinion. She's telling you where she observed that there is some things that he did or stated that she wishes to point out in the video. That's what it's doing. I'm not taking it as an opinion, but you have the opportunity to cross-examine her with regard to that she made an observation as to certain conduct or certain statements he made, and she wishes to bring those out. There's nothing objectionable about that.
Okay.
Go ahead.
Continue.
Thank you. So at 10 minutes and 21 seconds, Mr. Dolitsky is walking through the trees, and he made a comment, quote, "I don't like how noisy the leaves are," end quote. At 11 minutes and 5 seconds, he stated, quote, "I need to go back and secure my kayak. I don't want somebody to come to the dock and see it there," end quote. At 20 minutes and 7 seconds, he stated, "I just saw a truck on the adjacent property, so I'm just ducking down. I'm sure nobody has a clue I'm over here," end quote. At 20 minutes and 44 seconds, he said, quote, "Shit, there is that truck again," and ducks down, end quote. And during this time, you can hear a reverse warning sensor from one of the trucks on the property. At 27 minutes and 12 seconds, he states, quote, "I think I forgot to mention it, but I did go back and secure my kayak better, so it wasn't just sitting on the dock," end quote. At 27 minutes and 30 seconds, he stated, quote, "I actually kind of hid it, so if somebody came in that area, they wouldn't find it," end quote. At 30 minutes and 30 seconds, he states, quote, "I'm back to the dock. I think we're in the clear," end quote. And at 30 minutes and 47 seconds, he states, quote, that he was, quote, "getting my kayak from the hiding spot," end quote.
All right, the state will rest.
Ross?
I would first make an application at the close of their case for a directed verdict. I don't think that they've made out the allegations, so I make the application at the close of their case.
And in the close of the case, they just finished the direct examination. You have an opportunity to cross, so you're saying you're not...
No, I am going to, but he said he rested, so I'm happy to cross, but
He finished his direct examination, he hasn't rested yet.
I must have misheard. I'd like to ask you about the boat. You testified that your family owned the boat, is that correct?
My parents specifically.
Okay, and they're the owners of the boat, correct?
Well, they were while they were alive.
Who currently owns the boat?
I think that's a question of law, but it's probably part of the estate.
when you testified, you said your family owns the boat, correct?
Yes.
Is the boat currently registered?
No.
Is it seaworthy?
I don't know that I am able to give that opinion.
Well, do you recall there was a preliminary hearing in this matter on July 31st of 2025?
Yes.
And you recalled you testified?
Yes.
And you testified under oath, correct?
Yes.
Do you recall being asked this, actually giving this statement? And this is on page 5, line 6. And then he walked onto my property, and then he boarded a boat that I own on the property. Do you remember giving that statement?
That sounds familiar.
Okay. But now you're saying you don't actually know if you own the boat, right?
Well, the boat would be an asset of the estate. I'm the heir to the estate.
But when you initially testified, you stated you own the boat. Here you're very careful to say your family owned the boat. So which is it?
Well, again, the boat was an asset of the estate. I'm the heir of the estate. I haven't made any formal action to transfer title of the boat, but I am also the administrator of my parents' estates.
So is it fair to say when you previously testified that you owned the boat, that probably isn't true since you haven't actually transferred any title of the boat? Is that fair to say?
But again, I'm the administrator for my parents' estates, so, and I'm the heir. So as a practical matter, it would belong to me.
But it doesn't belong to you.
I'm going to object. This is calling for a legal conclusion.
She testified as to her conclusion.
I think it becomes argumentative now. I think she's followed through as to what it is, so semantics with regard to it. Is she the owner of the boat in her individual name? Is she part of the estate? She's made her statement, now it's argumentative.
You've testified that there are multiple signs, correct?
Yes.
Okay. There's a main sign, actually, you know what? I'm going to show you your State's Exhibit 2. There is a main sign somewhere towards the front entrance that's on the road, correct?
That's the largest no trespassing sign that we have.
And you'd agree that that sign is completely not visible from the waterway, correct?
Correct.
And you mentioned there are other signs inside the property, correct?
And there's other signs along the roadway and inside the property.
But you'd agree that none of those Mr. Zaleski passed, correct?
They're not depicted in the video. I don't know what he did or did not, the full extent of what he did or did not pass.
Well, you know where they are, right?
I know where other signs are located on the property, yes.
And you saw where he went in the video, correct?
The point I'm trying to make is that based on what's on the
but,
video,
you know,
I know what he
the
passed,
question was-
but I don't know what he passed outside of the video.
Okay, but based on what it's fair to say your entire knowledge of this case is based on the video, correct?
I don't know if I would characterize it that way, but my entire knowledge of what he did or did not do is based on the video, but I can't say for certain that's all that he did or did not do.
Okay.
I don't know what was edited out.
Without speculation, from what you are aware, is it fair to say that you did not see him walking in the vicinity of any of those signs? Is that fair to say?
Correct, other than the one that's located on the bulkhead.
Again, I'm referring to the other signs that are on the property, within the property, as you testified.
Yes.
Okay. Now, the yellow sign that's on the bulkhead, about how far from the actual dock would you say that bulkhead is?
I haven't measured the distance. I would say maybe 40 feet. I don't know for certain.
And that bulkhead is a seawall, correct?
I don't know what you mean by seawall. I consider a bulkhead. It's the end of the property.
It's a metal wall, right? That's right at the border of the property with the river, correct?
There is metal sheet piling there, yes.
And that piling is largely collapsed, correct?
There is a portion of it that is collapsed.
Okay. Now, that sign that you said that Mr. Deliski passed, can you describe the sign in a little bit more detail? For example, what is the relative size of the lettering?
I haven't taken a measure to the lettering. The sign itself is about 2 feet by 3 feet, approximately.
And you said it states no wake and no trespassing, correct?
Correct.
Are both of those written in the same size?
No.
Can you describe the difference?
The no wake is written larger than no trespassing.
And you mentioned that the sign is in black letters, correct?
Black letters on a yellow background.
Okay. And those black letters, to your knowledge, are still there?
Yep.
Now, I'd like to show you Defense J, which is a screenshot of a still from approximately 4 minutes and 39 seconds. My timestamp is based on a different video that was provided in Discovery, but is that fair to say part of the video?
It appears to be, yes.
Okay. And if you could just circle, and actually I would ask that be moved into evidence on consent. If you could just circle the sign with that marker and give me, please.
These markers, defense.
Defense J.
So the defense, we mark J, the defense, is a picture of the waterway looking at the kayak over to the property to the left, which is the own.
I have a black marker if that's easier.
Burn nicely.
All right, so, and I'll just should point out to the court that the witness highlighted a small, or circled a small yellow square to the far center left of the image. I'm not going to show you what I've marked as defense D, which I'd also ask to be moved in on consent. If you could tell me what that is.
It's a photo of the no wake, no trespassing sign.
Okay. And that is the same sign that you testified that Mr. Deliski passed?
Yes.
And that's the sign that you testified was yellow with black letters, correct?
Yes.
Okay. I'd like you to look at the words "no wake." Are those letters black?
I think it depends on the way that the light is reflecting on the sign. Referring back to your exhibit J, for instance, it's hard to see the sign, but I recognize that when I was trying to take a screenshot, it was hard to get a clear picture of the sign because of the way the video was taken.
But that is a fair and accurate depiction of the same sign, correct?
Yes.
Up close. What color are the letters?
In this particular photo, the letters themselves appear to be more orange than black, but there is still black. Again, it depends on the way that the sun is reflecting on the sign.
When you say they're still black, is there a single letter that is entirely in black on that sign?
There is fading of the black. I agree with that.
So it's fair to say that not a single letter actually has its full blackness, correct?
I would agree with that, but again, it depends on how the sun reflects on the sign.
Well, again, we're talking about the video in question. We can pull up the timestamp to see it on the screen, but we all agreed that, you agree, correct, that Defense J more or less accurately depicts the video?
Yes, it does.
Okay. And Defense D, and I'd actually like the court to see this, as she's testifying, to understand that the black sign that she's referring to, the black letters.
What is the,
Okay.
what is
Right, now, subsequent to this, you actually installed a sign on the dock, correct?
Subsequent to learning about Mr. Delitsky's video.
Right, so subsequent to the events depicted in Mr. Delitsky's video, you installed a sign on the actual dock, correct?
I installed many signs.
On the dock?
One on the dock, one on the pier leading to the dock, and multiple signs along the river.
Okay, but on the dock you installed one sign, correct?
Correct.
Okay, and I'm going to show you Defense E. Does that fairly and accurately depict the sign that you installed?
Yes.
In your opinion as the property owner, are those signs comparable to you? Can you read them equally well, or are there any differences that you've noticed? I'd ask to be moved in as well as an exhibit, the new sign that was installed after the fact.
Just for the record, the picture depicts apparently the dock and a sign listing private property without consent as Defense Exhibit E.
Right, and you'd agree that those signs are not very similar to each other, correct?
They're different, yes.
Okay. And would you agree that the no wake sign had been there for approximately 30 years
Yeah.
and had never been serviced to your knowledge, correct?
Never been, I'm sorry?
Serviced. Refurbished.
Answer if you know.
I don't know.
Now, you testified also that there's only one prior incident you knew of somebody entering from the dock, correct?
Improperly, yeah.
Okay. You don't have video cameras anywhere over there, correct?
I do now.
Okay. In the majority of the 30 years or so that you've had this property, up until after this incident, there have not been video cameras in that area, correct?
Not that I can recall.
Well, it's your property. Were they there or not?
Well, I took over ownership of the property after my parents passed away.
Okay, and the entire time you've owned the property, were there any cameras there?
Not prior to when Mr. Delitsky trespassed.
Okay. So it's fair to say, and you don't have a guard, you never had a guard there to your knowledge, correct?
No.
Okay, it's fair to say you really wouldn't know if anybody entered or not, since you're not there and there's no one actually monitoring the location. Is that fair to say?
Well, I wouldn't say there's nobody monitoring the location. We're on site every day.
But nobody's monitoring the dock, correct?
No, we go down to the dock on a daily basis. My bird manager was there this morning.
Okay, but you testified that, to your knowledge, nobody has ever entered from the dock without permission except for one incident, correct?
Correct.
Okay. But you would agree that that dock is not continuously monitored, correct?
There is a camera now, and again,
I will restate the question to be very clear.
Well, I'm going to object to it. I don't understand, Your Honor. Where is this going concerning this incident?
Well, she
at
chose to
that time in
testify
November?
about other incidents.
Cross-examination, I'm allowed to ask the question.
Again,
To the sufficiency with regard to it. The question is whether or not trespass occurred. What's going on now is not as relevant, but I'll allow you to ask the question because it's cross-examination. I'll give you leeway.
right, and again, they're the ones who elicited the testimony about prior incidents, so I think it's fair game now. They don't, you know, so anyway. So again, the dock itself is not continuously monitored, correct? Or it was not, up until you installed the cameras, it was not continuously monitored, correct?
well, again, we would routinely go down and inspect the dock as part of daily rounds.
That's not my question. I'm not asking you if you see it daily. My question is, is it continuously monitored?
Can you elaborate on what you mean by continuously monitored?
In other words, is it possible for somebody to have entered the dock while nobody was there, or in the, which one? You said somebody comes down to the dock on a daily basis, correct?
Yeah,
How long are they on that dock or in that area when they come down?
it varies.
Well, can you give me an estimate?
Again, it varies. It can be
24 hours?
Are you asking whether they're down there for 24 hours?
Correct.
No.
So it's fair to say it's not continuously monitored, correct? There's not anyone continuously seeing who comes to the dock or not. Is that fair to say?
Your question is, does somebody monitor 24 hours a day? She said, no.
Okay.
She said she goes there on a daily basis on her rounds. That's it.
Now, you signed this complaint. You indicated that this incident occurred November 1st, correct?
On or about November 1st.
Okay. Well, how did you come up with that determination?
I looked at a couple features in the video. The first being that we did have a tenant who docked his boat on the dock, and it wasn't in the video. And I contacted him to find out the exact date that he left, which was in August.
Object to that. That's hearsay.
It's not for the proof of whatever it is. Allow it, but it's no moment.
And then I also observed some trailers that were, we had moved down to the dock that were depicted in his video. We moved those down there in September. The video itself was posted on November 13th, 2024, so I knew it couldn't be beyond November 13th. And then I looked at the condition of the foliage and the sun and the tides to determine approximately when he was there based on the weather and the tides. When he first kayaked, it was in the afternoon and it was low tide, but the tide was still going out, which I could see based on the condition of the sheet piling still being wet at the bottom, which would indicate that that it had been wet and the tide was flowing away. And then you can see at the end of the video, as it's getting closer to sunset, which he talks about in the video, and then the water coming in such that he was able to kayak up the creek to the boat. And using that information, I reviewed the tide table and the weather and determined it had to be around November 1st.
Okay. I just want to go back to something I asked you. Up until you saw the video, you had no idea that Mr. Jaliski entered your property, correct?
Up until I was informed about the existence of the video.
Okay. But until you knew about the video, you had no idea he went on your property, correct?
Correct.
So, is it fair to say that if he was able to enter the property without anyone seeing him or anything of that nature, and without you even knowing about it, that he may not be the only person, correct?
Correct.
Now, you testified on your direct to a bunch of things that Mr. Jaliski said in the video. Did you also hear him say that there are no signs and that he didn't see any signs?
I did.
And that was on the video too, correct?
Yes.
And you also heard him say, whose boat is it? We don't know, correct?
Yes.
Now, the dock itself, is that actually on your property?
All the dock is floating on the South River. I don't own the South River.
Okay, so the dock is not actually on your property, correct?
The dock is not, but it is my dock and is attached to the pier attached to the property.
That's not the question. I'm just clarifying the dock itself is outside your property line, correct?
Yes.
Thank you. One moment. Now, the area around the inlet where the boat is it fair to say that that's largely a marsh area?
Yes.
And it's not developed itself, correct?
Uh,
The area
not-
where the inlet is?
Not immediately adjacent to the creek where the boat is located, although at the end of that creek, it is developed.
One moment.
And to clarify, I don't know that it's all marshy, but it's certainly a woodland with trees and grasses.
And the boat, is that actually, is it floating or is it hitting the bottom?
It's my understanding that she rests on the bottom.
And does she have any propulsion?
There's no, I don't know if the propellers are still attached, but there are no working engines in the boat.
Is it fair to say that other than being owned by the estate, it is largely abandoned?
I wouldn't say that it's abandoned. It's in the creek that's within our property.
When's the last time you utilized the boat in the time that you or your estate have owned it?
I don't recall.
So it could have been last week?
It wasn't last week. I don't recall the last time I was on the boat.
In the time that you've owned the property, had you gone on the boat for transportation in the entire time you've owned the property?
The entire time my parents owned the boat, it has not had working engines in it, so it has never been used for transportation.
That's the time your parents owned the boat? And you, correct?
Correct.
Okay. And there's no electricity on the boat, correct?
Not currently.
Okay. Now, there's also significant graffiti on the boat, correct?
Yes.
Okay. Mr. Dlisky didn't do that graffiti, correct?
Not to my knowledge.
Okay. You didn't do the graffiti, correct?
No.
Okay. So it stands to reason that other people who entered the property did that graffiti, correct?
I don't know that they entered the property or if they entered the boat directly.
Well, isn't the boat on your property?
It's in the creek that's within the property.
So they would, is it possible to get to the boat without entering your property?
Well, your client kayaked up to it.
But the creek is in your property.
Well, the waterway feeds off the South River, so the water itself is not the property, but the land on 3 sides of the creek is.
Oh, and just to clarify, there's no fencing your property line to the west of the property line, going back to Stage 2. There's no fencing along that line, correct? That leads on the northbound line.
Are you referring to the property line that runs perpendicular to the river on the left side?
Correct.
Yeah, so a portion of that is railroad tracks, and then a portion of that is through marsh.
But on the, right, but there is no fence at that border, correct?
Well, you couldn't install a fence because it's a marsh.
Understood. Is there a fence on the other border, on the other end? On the, to the east?
No, no. Most of that is wooded.
So is it fair to say that other than that one sign on the water, there is no other demarcation of what your property line is, or where your property is? Is that fair to say?
Well, I think the bulkhead and the space behind it that we use indicates that it's the property.
But I'm referring to the large tract of land before you, so the bulkhead and the sign are the same place, correct?
Yes.
Right. Other than that, is there anything demarking your property in that entire large stretch of land along the river?
To the left of the bulkhead, there is a boat ramp, and then it's wooded with trees that my family planted during its ownership.
I'm
That
sorry.
would lead up to the creek, and then on the other side of the creek is wooded.
So is it your position that the trees your family planted are notice of the demarcation of your property? Is that
Well,
what
they're not natural trees that I mean, they were placed there by human hands.
And you would expect people to just know that? Because remember, the question is there a demarcation of property? You're saying, well, we planted these trees, and they're not like native to that area. Is it your position that those trees are sufficient notice?
Well, I didn't say that they're not, quote, native to that area. What you can see from the video that when he walks up the ramp onto the pier of the dock, that it is developed down there. There's buildings down there, there's trailers, there's a concrete road, so you can see that it is private property.
Again, your property goes well beyond the developed area, correct?
Yes, I mean, it goes back to the roadway.
Okay, and it's approximately a 60-acre lot, correct?
About, yeah.
And the developed portion along the water is largely developed by the road, is that fair to say? Not by the water. The majority of the development is by the road, correct?
I don't agree with that statement.
Okay, well, we'll just let everything speak for itself.
The question is, to get access to your property, there's access from a roadway, is that right?
Correct.
And is there an entrance onto the property?
From the roadway?
Yes.
Yes, there's one main gate that's open.
And is it fenced so that the only way to get through that would be to go through a gate?
Yes, Your
Those
Honor.
are the questions I think he's asking.
Yes, there is
That's
a,
an answer that I would need also. So is there fencing that's in the front that would stop somebody from coming onto the property without going through the gate?
yes, Your Honor. On the roadway border, there is fence that runs along from the railroad all the way to the woods, and there is one main gate that's open, and that's the only access from the roadway unless someone were to trespass through the woods to come in.
My questions have prompted anything from you, certainly you may ask them.
Just, can any of that fence be visible from the waterway?
No, I don't think so.
Okay. And other than along the road, is the property fenced on any side? Understanding that one side is water. Is it, of the four sides of the property, other than the road, is it fenced?
No, because again, on one side there's railroad tracks, and then there's marsh that's impassable on foot. On the other side, there's trees, it's wooded, and then along the river, the river itself forms a natural barrier.
I don't have any other questions.
Redirect?
No, Your Honor. Submit DE.
Is the picture with regard to the new signs that are up as the bulkhead or the dock and bulkhead. Any other things that you wish to submit into evidence?
No, Your Honor.
Okay, now we go to you, Mr. Uriel.
I would call George Lurie, please.
Did you renew your application?
I'm sorry, I believe that this was on consent, but I would ask to call George Lurie.
Okay, so you're not going to renew your application, I just want to...
Oh, I'm sorry, I misheard you. I am renewing the application at the close of the prosecution's case since they're arresting him.
Now, to the, in this particular case, I think the state has provided sufficient information to show at least a prima facie case that trespass has occurred with regard to it. So I'm going to deny your application, but I just wanted to make sure we covered all the bases.
Specifically to the boat judge, I would argue that they haven't established ownership. They can't make out a prima facie case boat.
Not particularly with regard to it, because it doesn't say particular road, it's about trespassing. So that's what I'm denying your application. Go ahead, you want to bring a witness?
Well, Judge, if I may, just very respectfully, there is a charge that specifically refers to a vehicle, aircraft, or watercraft, and that's the 2D. And that's the one I don't believe they've made out, because they haven't established any boat that she owns that she can make out a charge on that. So I would argue that that one is just insufficient as a matter of law.
There's been testimony that there's a boat. In the video, there is a boat. I think the boat was referred to as the Blue Jacket. There's video of Mr. Dolitsky being on the boat. She's testified that she owns the boat, whether it's through an estate or whether it is, or that she's the beneficiary. So her delineation of it is that she's the owner of the boat. I think is sufficient, and that there's been information to show that he was on the boat, that he's on the property. Then the question becomes whether it's abandoned. She said she hasn't abandoned, it's just not been used, it's never been used, but it's on her property and it's property. So I'm denying your application. Next question. You want to bring a witness?
I would ask, actually, one moment. I'd ask to call George Laurie, please.
George Laurie? Is there a George Laurie? Yes, sir. Would you step up? Mr. Laurie, I'm going to ask that you, is there a chair in front of you anywhere? No, not back there. I'll tell you what, I'll ask, because of the microphone, I'll ask Mr. Dolitsky to sit back, and then you can sit in his chair so that we can get your testimony and it can be recorded on the microphone. Mr. Dolitsky, would you stand up, please? I'm sorry. Mr. Murray, raise your right hand. Tell me, swear to tell me the truth, the whole truth, and nothing but the truth.
I do, Your Honor.
Okay? And you want to spell your first and last name?
George Lurie, George Lurye.
By whom are you employed?
I am self-employed. I work as a contractor.
And your primary income is from what employment?
I work as a paralegal,
And who do you work as a paralegal for?
Uriel Criminal Defense.
And are you here in your capacity as a paralegal for Uriel Criminal Defense?
No.
Are you getting paid by Uriel Criminal Defense or anybody for being here?
I'm just having my tolls paid and gas by Mr. Dolitsky.
Okay. Now, let me ask you a question. Other than your work as a paralegal, do you have any other training or experience related to maritime matters?
Well, yeah, I spent 15 years as a U.S. Coast Guard auxiliarist.
And can you talk about your education training, what you did there?
Over 15 years, I have been a Marine Safety Officer on Staten Island in my flotilla for 2 years. I have then been a Vice Flotilla Commander, a Flotilla Commander, which is a unit commander, and a Division Commander overseeing all operations for the U.S. Coast Guard Auxiliary within the AOR of Staten Island, New York.
And can you tell, go
I'm
ahead.
sorry, I'm also a Recreational Boating Safety Specialist, certified.
What does that mean?
The U.S. Coast Guard Auxiliary is in charge of the U.S. Coast Guard's mission in advising, assisting, and teaching recreational boaters on boating safety.
And what leadership positions have you held in the Coast Guard Auxiliary?
Well, as I said, I've been staff officer in marine safety and member training and numerous other positions. Vice commander of a unit, commander of the unit, and then division commander.
And as part of the courses that you teach, or do you instruct people on nautical signage?
Yes, it's a part of our boating safety courses.
And are you familiar with nautical, the standards for nautical signage?
Yes.
And can you just describe generally what they are?
Depends on what they're trying to, what message they're trying to convey. There are signs and buoys for warning signs. There are signages that show where you can and cannot moor. There are signs for where you can and cannot boat.
Specifically, are you familiar with no wake signs?
Of course.
Can you tell us what a wake is?
A wake is a disturbance in the water that follows a vessel, and it creates hydromotion behind the vessel that can cause damage if it's too strong.
Can a kayak leave a wake?
Technically, yes. However, that wake would be very, very, very small.
Can a kayak leave a wake as envisioned by the sign?
You mean as to
A no-
why signs will be placed?
If there's a no wake sign, is there anything a kayaker could do to, does a kayak leave any significant wake as addressed by the sign, to your knowledge?
No.
What kind of wake is that sign referring to?
Mostly motorized vessels.
And are no wake signs, to your knowledge, legally enforceable?
Yes.
In what circumstances?
Well, there's civil enforcement on any damage that they may cause with your wake. And then a wake can be enforced in the criminal world as well, if it is excessive, because it's akin to speeding.
And so if I put up a sign, that would be legally enforceable?
As a random person?
If I put a sign on my property that says no wake, to your knowledge, is that enforceable?
No.
Why not?
It's a legal sign. It has to be put up by the government.
And is there a specific way those signs look when put up by the government?
Yes.
Can you describe that?
The no wake specifically?
Correct.
It should be a white rectangular sign with black lettering and orange piping on it.
And can the official signs have more than one instruction on them?
No, you would have to have multiple signs.
And are there any official signs that also state as part of no wake, no trespassing?
No, because no trespassing wouldn't be applied to boating.
Can you have a no trespassing sign on a waterway?
Probably. I'm not a specialist on that.
Okay, fair enough. Now, you said that you did vessel inspections, correct?
That's correct. That's probably part of my duties.
And in doing that, did you go on private property?
Marinas and private property, if someone has a boat on a trailer or something like that in the driveway, yes, regularly.
Okay, and when you say a boat, what would be a boat to your understanding?
A vessel, well, that's defined actually under law, the federal law, USC 1, I believe, Section 3.
And to your knowledge, what does that say?
Do you want me to quote it? Do you want me to paraphrase it? Or?
Well, are you familiar with it?
Yes.
Okay, do you recall it off the top of your head?
Not verbatim.
Would anything refresh your recollection?
Yes, if you have a printout of it, you can show it to me.
Definitely not. So, I'd ask to show the witness I'd ask to show the witness one moment. Oh. Okay, if you could paraphrase what your knowledge is of what it states.
Sure.
Actually, I'm sorry. I'd ask to show the witness 1 U.S. Code 3, just to refresh his recollection. Any objection?
No objection.
So it states, a vessel is including all means of water transportation. The word, quote, vessel includes every description of watercraft or other artificial contrivance used or capable of being used as a means of transportation on water.
Now, you observed the video that was put in as States 1, correct?
Yes,
And you observed the condition of that boat.
yes.
Can you describe how you observed the condition of that boat to be?
It appears to be derelict. There's definitely structural damage, a lot of structural rust, I believe in a couple of cases, I even saw either trees or bushes growing through the decks, missing chunks of deck. And I believe there was water in what looked like to be engine compartment. So it looked like it to be flooded, and the vessel looks like it is definitely grounded.
I don't have any other questions.
Cross-examination.
A question, you stated that a no-wake sign must be an official governmental sign?
It has to be either placed in New Jersey by a state police officer, state trooper, or it has to be authorized to be placed by a state trooper.
Can anyone put up a sign?
Only if authorized to do so
Okay.
by a state trooper.
All right, no further
I
questions.
have one question. What is your basis for that last comment, the statement that you made?
A New Jersey state regulation.
Off the top of your head, do you remember what it is?
I do not.
Would anything refresh your recollection?
Yeah, if I could see it.
I'm gonna show you. Does this refresh your recollection?
Yes, and JAC 13:82-1.7 is the statute.
And, Your Honor, I would just ask, so no further questions, but I would ask the court to know that the statute specifically states, no person shall place, anchor, or construct any buoy that states or implies that an area is a slow-speed, no-wake area, except as provided in certain subdivisions. Okay, I don't have any further questions for this witness.
Any further redirect or recross?
How long was that regulation in effect, if you know?
I do not.
Okay, thank you. No further questions?
Okay. Thank you, Madam President.
I'd call Mr. Dolinsky.
Okay, Mr. Blitzky, would you please stand? Raise your right hand. Solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
Mr. Dolinsky, where do you live? What state?
I live in New York,
And what county?
Suffolk,
And how long have you lived there?
4 years.
Do you live with anybody?
Yes.
And currently, what do you do for work?
I have a YouTube channel called 2 Feet Outdoors.
And can you describe what the content of that channel is?
Yeah, I have a passion for the outdoors. I like to go kayaking, hiking, backpacking, camping, exploring different areas, pretty much everything outdoors, and I make videos of my trips.
And how many subscribers do you currently have?
Almost 51,000.
Now, prior to living in New York, where did you live?
I lived in Vermont.
And can you just tell me what you did for work around in Vermont?
Yeah, I was in Vermont for approximately 4 years. 2 of those years, I was an asset protection specialist for a large supermarket. And 2 of those 4 years, I worked in the ski industry.
And prior to that, where did you live?
I lived in Florida,
How long did you live in Florida?
25-ish years.
Now, do you have any kind of formal education?
Yes.
And what is
Your
that?
Honor, if I could object, what is the relevance of this?
Judge, credibility is central. I have a right to establish my witness's credibility, and I only have a few more questions about his background.
Giving you leeway with regard to it, the relevancy is really very remote because I want to focus us. We're here for whether or not trespass occurred. And so integrity isn't an issue at this point with regard to it. We're just trying to find out whether or not it trespassed.
Well, the issue...
I'm giving you leeway to do it, but you're not giving me information that helps me with this case. So I tell you that in advance to get to the point.
Okay, so is it fair to say that you have an Associate's of Criminal Justice from Farmingdale and then a BA in Criminology from the University of Florida?
Yes.
Okay, and after graduating criminology degree, what did you do for work?
Beginning in 1993, I became a police officer.
Where?
Cape Coral Police Department,
And how long were you at Cape Coral Police?
approximately 4 years.
And then what did you do after that?
I transferred to the Tampa Police Department.
And did you ultimately retire from the Tampa Police Department?
Yes.
All right, now I want to direct your attention to October 30th of 2024. Were you doing your current job at 2 Feet Outdoors that day?
Yes.
And what were you doing that day for your job?
I was planning on kayaking the South River to locate and check out an abandoned boat that was stuck in a creek.
How'd you hear about it?
I saw another YouTube video about it, and it kind of intrigued me, so I wanted to...
Did you know where the boat was specifically?
I had an idea.
At the time, were you aware that it was on anybody's private property?
No.
At the time, did you have a plan for how you were going to get on the boat?
No.
Did you have a plan to dock anywhere at the time?
No.
Now, you gained access through the South River Boat Club, correct?
That's correct.
And when you first got on the water from the South River Boat Club, is the boat to your... I'm sorry, is the boat club on the same side of the water or the opposite side as the boat and her property, the complainant's property?
Opposite.
Okay. And when you get to that boat club, did you initially go east or west? Or which direction did you go?
I ended up going left, like northwest.
And is that towards the boat or away from the boat?
Well, it ended up being away from the boat.
And how far did you go?
I went 2 bridges. There was like a railroad bridge and then a larger bridge, and then I realized I was going the wrong direction.
And then is it fair to say you came back?
Yes.
And at that point, is it fair to say you kayaked up to the creek? Actually, one moment. I'm going to ask to put into evidence defense F.
What is it?
It's just a map with pre-marked with locations.
Okay. I would say that this is more of a photograph than a map. But,
It's fair enough. It's an aerial view from a map software of the location of the general property. Is that?
okay.
And do you recognize this?
Yes.
Can you tell me, is the boat club that you launched from, is that visible on here?
Yes.
And is it numbered?
Yes, number 1.
Okay. Now, the dock in which you, I'm sorry, initially you went to the creek, correct? Sorry, after you turned back around, you initially found the boat when you got to the creek, correct?
Correct.
Is that numbered here?
Yes. Number 4.
And then afterwards you went to the dock, correct?
Yes.
Is that numbered?
Number 3.
Okay. Now, can you see the boat in there?
Yes.
Is that numbered?
Number 5.
Okay. Now, as you were boating on this, kayaking on the South River, back and forth, did you notice any signage at all in that area?
I didn't.
Now, at some point, did you go back?
Yes.
And when we say go back, where did you go back to?
I went back to the South River and launched my kayak.
Do you recall roughly when that was?
Yes, that was, I believe, June 6th.
And when you did that, why did you do that?
Because I wanted to take a look at the dock and see if there were any no trespassing signs put up after the fact.
Okay. And have you had an opportunity to view Defense Exhibit E? Well, actually, no. Defense Exhibit E. Yes, E. I'm sorry. Did you have a chance to review that exhibit?
No.
If I could just show them. Do you recognize Defense E?
Yes.
And what is that?
I took that photo and of the sign that says private property, no trespassing.
And was that the same date that you initially made your video on October 30th of 24?
No, that was the first time I went back.
And did you actually enter the property on that date?
No.
Okay. And did you go back again to the waterway?
Yes.
Why was that?
Because you asked me to.
And what was, can you explain why, what was the reason I asked you to go back?
Because there was apparently some other sign along the waterway that was potentially there.
So you went back the second time to look for the new sign, correct? When you took the picture of that sign, you were looking for signs in general, correct?
Correct.
And in that second instance where you came back, did you see any other sign but the new sign that was put up?
No, I only saw the sign that was on the dock.
Now, when I asked you to go back, did I tell you specifically where to look?
Yes.
And that time, did you see the sign?
Yes.
Okay. And did you document that sign?
Yes.
And to your knowledge, is that Defense D? We can show it to you if you like.
Yeah, I believe I saw it. And it appeared to be the photo that I took.
And that fairly and accurately depicts the sign that you saw?
Yes.
What color were the letters?
Yellow.
And you saw it in person, correct?
Yes.
You saw it from different perspectives, correct?
Yes.
Under any perspective, did the light hit the letters so that they were black?
No.
Under any perspective, the light hit the letters that you believe that it was orange?
No.
And how would you describe the sign in general?
It definitely appeared to be very old and worn and not legible unless you were really close to it.
Now, at some point you moved the boat off the river and you made some statements about not wanting people to see the boat, the kayak, correct?
Yes.
Okay. Can you just explain why you did that?
Yes. Anywhere I kayak, I always want to make sure that my kayak is secured, because if somehow it disappeared or got stolen, I'd be stranded.
All right, so let me just bring you back. When you, on the date in question, October 30th of 2024, when you got to the dock, after you went to the creek, what did you do? On October 30th, after you kayaked back to the dock, what did you do?
I took the kayak out of the water, put it on the dock initially, and then walked up the ramp to the land.
Okay. And when you got to the land, can you describe what you immediately saw in front of you?
I saw one trailer from like a tractor trailer off to the left.
No tractor?
No tractor.
And any buildings?
I saw one building to the right, and it was all boarded up.
And Further down, did you see a development?
I didn't notice any development.
Can you describe how you went from the dock to the boat when you crossed across land?
Yes. Immediately as I went up the ramp and then entered the land, and then I immediately made a right-hand turn along the, I guess you'd call it the tree line, and eventually I came to what looked like a trail, but it was heavily overgrown trail.
Did you have any idea where the property lines were at that point?
No.
And did anybody come up to you and tell you to leave?
No, I didn't see anything.
In your entire time on the property, did you see any signage that would indicate that you were not allowed to be there?
No.
Did you have to cross through any fences?
No.
And the boat itself, were there any signs on the actual boat indicating that there was no trespassing?
No.
What was your impression of the boat when you saw it? What did you believe it was?
It was, I thought it was an abandoned boat. Very poor condition.
Have you ever been back on the actual property since then?
No.
Okay. I don't have any further questions.
Cross-examination.
No questions, Your Honor.
I have a few. Mr. Delitsky, you received permission to take off from the South River Yacht Club. You wanted to take a look at this boat. Why didn't you ask permission?
I had no idea who owned the boat. I just believed it was an abandoned boat stuck in a creek.
Did you ever go to the front of the premises to see if there's somebody that you could speak to?
No, I had no idea that that boat was associated with anything around that property. I just thought it was a 110-foot yacht stuck in a creek.
So you never went around to the front to see whether or not it was a gated community or a gated area?
Correct. That was my first time to Sayreville.
And you tried to avoid being seen by people. Why did you do that?
You know, a lot of times when I'm making a video and I'm recording and walking around with a video camera, you know, I just try to film without being seen. Because some people do kind of react to people with cameras.
Now, it's been brought to your attention, you're aware that this no wait, no trespassing sign was located at that property, correct?
Yes.
You made another comment somewhere along the line that said, oh, great, we're in the clear. Why did you make that comment?
Basically that I was just kind of like wrapping up towards the end of the exploration, if you will, and from that point, I was gonna get on the kayak and paddle around to the creek.
Have my questions have prompted any questions from the state?
No, Your Honor.
And I would ask again, Mr. Uriel, if my questions have prompted any questions of you, you may ask it now.
Just to clarify, up until the third time that you went to that location, had you ever noticed that sign until the third time when I specifically asked you to go there?
No,
Is it that, and just to be clear, is it that you noticed it but didn't bother to read it, or that you simply just didn't even notice it?
I never noticed it.
Nothing else.
Any further witnesses?
I have nothing else. No other witnesses.
All documents and everything that you wish to enter into evidence?
No, I do want to enter the transcript from the hearing into evidence. I know we had said we could put that in on consent, so I would like to have that in.
Any objection from the state?
No, Your Honor.
Okay. And I'm going to hand up defense B.
Hold on, this will be moved in as, the joint exhibits, so I'll put it in as, I'll put it in as D4. D1 actually, because we didn't use any numbers, but it'll be D1.
Oh.
Which is the transcript of the probable cause hearing, but the indication is that it was used to figure out whether or not it was ownership, and the question was with regard to ownership by this or anything further?
Well, yeah, I mean, because it's in evidence, I am going to reference other portions of that, not just that one portion. But that'll be my closing. Otherwise, defense rests.
Any other evidence that we haven't already marked and put into evidence?
Just to verify, F is in evidence, because I still have it. What I marked as F.
We talked about DF, which is the map of the locations in the aerial view, so it was more of the picture apparently.
Correct, the picture.
Any objections to DF going
No, Your Honor.
DF will be in evidence if you hand that up to us.
Thank you.
All evidence that you wish to put in is now in evidence.
It is, Judge, thank you.
Mr. Krenzel, all evidence that you seek to put in is in evidence.
Yes, Your Honor.
I wish a few moments before summation. If you wish to have a summation.
I definitely do.
And I also wish.
You need a few moments, Mr. Krenzel.
I have my notes here, Your Honor.
Okay, you're ready to proceed.
Thank you.
If you need a few moments.
Thank you.
Why don't you just take a few moments, we're going to take a 3 to 5 minute break.
My plan is basically to run through all these various items and point by point bring them out as to what we did, adding on to other things that were said that are immaterial. Well, that's what Mr. Judge was trying to get him, when he said it. Why didn't you ask for permission? You knew that wasn't. Without being seen, Unfortunately, I know this judge, and I don't think so. So hopefully, I think he's going to go with our favor. I don't know if this is, again, I don't think so, but I think this one is like, this one.
Yes, I can understand.
You see, when he refers to that, when I looked this up, I said, hey, but no deed. That's not how it's listed on the, when I looked it up on the internet there. I have ways of looking at this.
Right.
Yeah.
The thing is, I also know New Jersey.
So, so I'm just going to go through each of these around.
His expert testified that he had a definition of vessel, which is, I don't know if he's going to like that, but that's different.
Well, my thing is, as far as Mr. Gore is concerned, he was never never made an expert.
Yes. He's employed by defense counsel.
Right. Yeah, he's going to take it for what it is.
Right.
As you heard him said, like, I weigh it down. So.
Hold on. I understand.
Confuse myself.
You and I are in agreement.
That's and he's right. These two aren't going to go anywhere. These are examples of this.
Yeah, well, I know where that is.
Ask a question. I'm trying to. I'm trying to do it. Like, really?
All right.
All right, we're back in session.
Court's back in session.
Just address the journalists if there's anything that they have to do when they're back in session. Otherwise, we'll start. Okay. Back on the record. Mr. Uriel, you want to be heard on some issues?
Yes, please. Judge, I'm just going to start by referencing a case called State v. Pierce, which I am giving a copy of to the court and to the prosecutor. And I'm going to just note a few points that were made. Now, this is a county decision from 1980, but it makes some interesting points that I think are important. And it states, and this is State v. Pierce, this is 175 NJ Superior 149, and it states, generally a trespass as such is viewed as a private wrong and was not an indictable offense under common law. Any criminal sanctions against a trespasser must necessarily be statutory. The common thread that runs through the prior legislation is the notion of intrusion. Most people have no objection to strangers tramping through woodland or pasture, but a building is generally intended to keep out persons not licensed by the owner. This law and all subsequent trespass laws have in common a notice requirement. There must have been conspicuously posted notices on the land forbidding trespassing or personal notice to the defendant forbidding him from trespassing. This notice against intrusion onto real property is a substantive element of the offense. None of the trespassing statutes were intended to redress private wrongs. The purpose is to protect the actual possession of real estate against unlawful enforceable intrusion. Unless it is committed with force of violence or a breach of the peace, no conviction will lie. The view taken is that the legislature did not intend to punish criminally acts committed in ignorance, by accident, and it gives some other examples. A claim of right and all that. So I'd ask the court to consider that case as a framework. And the very last page of that decision, it states, in conclusion, the purpose of our trespass statute is to prevent unlawful intrusion into real property or breaches of the peace relating to realty. Then there's State X Rel JSJ, that's from the Appellate Division, and that's 2011 New Jersey Superior, it's an unpublished Lexus 2297. I'll hand that up. Actually, I'll hand up the other cases as well, just to save time. I'm also handing up Evansville Bowling Green Packet Company versus Chero Cola Bottling, which is 271 U.S. 19. That's a U.S. Supreme Court case. And also Middlesex County Health Department versus Roessler, which is from the Superior Court of New Jersey, Middlesex County, April 1986, 235 NJ Superior 262. And I'll note in State X Rel JSJ, this is a case, and I think the facts are important, where, and I'm reading from the decision, Hillside Detective Stephen Costa testified that a photograph of the building where the assault occurred depicted a sign on the side of the property that read, "Private property, no loitering, no trespassing, tenants only." And the decision goes on stating that the trial court found that the sign posted on the side of the building satisfied the notice requirement in NJSA 2C 18-3B2. The record before us does not support the findings. The lower court also stated that because he was there to do something wrong, that he knew he wasn't allowed to be there. And the appellate court rejected that reasoning. And they stated that JSJ's mere presence in the foyer of the building does not establish that he knew he wasn't authorized to be there. And I'll point out that's actually inside a building. The detective, and I'm quote from the decision, only testified that the sign was, quote, on the side of the building. The record does not show that the distance the sign was from the ground, how large the lettering was, or whether the sign was illuminated. And then again, I quote at the end of the decision, given the lack of specificity as to the location and size of the sign, we are unable to ascertain whether this posting was reasonably likely to come to the attention of intruders. The record does not support the trial court's finding that JSJ was constructively unnoticed that he was not licensed to be in the building. And Judge, I will note, the other case, Middlesex County versus Roessler from 1989, is actually regarding the very same property, the Viking Terminal on Journey Road. This case is about the same property. This is from the Middlesex Superior Court. In that case, they were repeated warrantless searches by government officials, and there was an attempt to suppress the results of those notices because at the time the property had fences and no trespassing signs. And while this is granted a slightly different legal standard, I think it's still relevant that the court found that it is an open field, that the open field exception applies, because steps to, and I'll quote the decision about the very property in question, steps to protect privacy, such as erecting fences and posting no trespassing signs, do not automatically establish a legitimate expectation of privacy in an open field. No expectation of privacy legitimately attaches to open fields, right? And I ask you to remember that in the context of the other decisions that I read, which discusses how, you know, the whole purpose of the trespass statutes is to punish very specific behavior. And it's designed to protect essentially people's privacy and people's rights to property. Now, let's go to this case. There is one last case I would point out, and that's the issue of what a vessel is. And I'll just point that out just so we have a framework. I will note, Judge, as to the vessel, that there are several New Jersey statutes. There's no specific definition as to what a watercraft is in the municipal code. There's no specific reference. However, besides what Mr. Lurie testified to, that 1 U.S. Code 3 talks about a boat as something capable of transportation, I'd also note that while there is no specific definition in the municipal code, NJC 1345A 23.1 states watercraft. And again, the word in the Sayreville statute is watercraft. Watercraft, and I'm reading pertinent part, it includes but is not limited to any craft, boat, vessel, power, sailboat, motor, sailor, documented or registered in the state of New Jersey. So that definition specifically talks about having it being registered. In NJC 12-7C-8 from Title 12, it defines a vessel, and it specifically defines that in sub A as, which is capable of being used as a means of transportation on the water. And going back to that U.S. code, I'll point out the last case, which is Evansville from the Supreme Court. And there the court found, and again, the legal questions are slightly different, but I think the reasoning is relevant. The only question presented is whether appellant's wharf boat was a vessel at the time that it sank. It was not used to carry freight from one place to another. It was not practically capable of being used as a means of transportation. It did not encounter the perils of navigation to which craft used for transportation are exposed. And it ultimately determined that we have found none that supports the contention that this wharf boat was a vessel. So I'll point that out. Now, in this specific case, Judge, you heard from Mr. Deliski. He told you that a lot about what he does, the videos he takes, and you saw that he was diligent. Where he knew that he was directly crossing through someone's front gate, he asked whether he could use the link, whether he can cross. Where it was very clear where the property borders were, he did. We watched that video, and I submit that nobody who saw that video would have observed that sign. The complainant testified that the sign had black letters with yellow writing. But that is objectively not true. No matter how the sun hits it, there is almost no black left on those letters. The yellow is faded. It is essentially yellow on white, at best. Moreover, the sign in large letters says "no wake," a sign that a reasonable person who is in a kayak would, even if they could see that sign, and I submit nobody could have really saw that sign, would not continue to read. Moreover, the no wake portion is not enforceable because it's not an actual standard no wake sign, as Mr. Lurie told you. It's definitely not a no wake sign that was put up by the state police. The no trespassing is written in tiny letters that would be hard to read even if the sign was in its original yellow with black. But from the waterway, I submit it literally blended with the foliage. Now we talk about fencing on the front of the property, but what relevance is that? There is no relevance because the statutes for trespass, and this is both Sayreville A and well, specifically Sayreville A. By that I mean Sayreville 5-13 2A. That statute specifically reads, and then that trespass is enumerated, right? The acts of trespass are enumerated, and sub A, any entry upon the premises or any part of another, including any public property, in violation of a notice posted or exhibited at the main entrance to the premises or at any point of approach or entry in violation of any notice, warning, or protest given orally or in writing by any owner or occupant thereof. Now, this necessarily envisions that obviously it's not reasonable to read the statute to mean that you can either have a notice on the front or any point of approach. Because otherwise, you could just have one entrance on some random tree that was planted by somebody's family, not on the main gate, and that would count under the statute. If you read these as an either or, but in reality, the statute implies very clearly, and especially in light of the case law, that the notice has to actually be on the point of entry relevant to the entry. Having a sign literally on the opposite end of a 60-acre property that is largely swamp is not constructive notice, especially when that sign is so faded that one cannot reasonably see it. Now, we heard a lot of testimony about what his intentions were, what he was thinking. I said it doesn't matter. He could have known completely well that that's not his property and that he didn't have permission in. But that's not the same as a trespass as defined in the statute, as a defined trespass. And that's largely because of the case law that I explained, that the purpose here is to really address violations of property. And even the courts noted that most people wouldn't care if you just cut through their land on some swamp. Nobody would care. So if you want to care, if you want the courts to enforce your right, you have to do more than have a 30-year-old sign. And I submit that the complainant knows that, which is why she now has installed very clearly legible signs. And I submitted those signs were there but wouldn't even be here. But they weren't. They weren't there. She testified about all these little signs throughout the property without any clear indication of where they are, but admitted he couldn't possibly have seen them because he didn't go by them. And I submit her testimony was a little bit disingenuous. She's using this video to demonstrate what she believes is a trespass onto her property. At the same time, she's claiming that she doesn't really know what happened because, well, I don't know where he went or where he didn't go. She argued that nobody could have come on the property besides what she would have known, and yet Mr. Dolinsky himself demonstrated you can go on the property without anybody knowing. So a lot of this is bootstrapping, attempting to state, the sign was in black letters without actually putting it into evidence, coincidentally. Mind you, it wasn't put into evidence except for by the defense. The court, had it just been through her testimony, might have been led to believe that the sign was actually yellow with black letters. And she carved down, doubled down on, well, they're kind of black in the right lighting. Judge, I said that's just not credible. And it's more consistent with somebody who's trying to vindicate something that's not vindicatable by the law. The law doesn't support that just because it's private property, there's a trespass. Now, as for the boat, that's charged as 5-13-2D. The Sayreville statute specifically references entry upon any vehicle, aircraft, or watercraft made without consent of the person having the right to the possession or control thereof, or a failure or refusal to leave such vehicle or craft after being requested to leave by the person having such right. But I would note, this is not a vehicle, it's not an aircraft, and it's certainly not a watercraft. It is debris in the water. Now, she says, now she's saying it wasn't abandoned, because that's relevant, right, if it's abandoned. Now she's saying it wasn't abandoned, but I would point out, in the transcript that was put in as, I believe, D1, and I would note that on page 6, line 4, she testified that, line 5, it's not in good shape, she is not usable, she hasn't been usable for some time. So, we saw that the law indicates that a watercraft needs to be something that's capable of transportation. I'll also note in her original testimony, she doesn't mention anything about all these additional signage. She only refers to the sign on the front and the yellow sign that was faded. One moment. I'm sorry. And I'd also point out on page 8, line 25, she stated then, actually now it's on page 9, she stated that she doesn't consider it abandoned, but she also doesn't have a definition of derelict. So, Judge, you've seen the video. The boat, if we can call it a boat, is in the water, hitting the ground, not floating, has no electronics, no instrumentation, heavily graffiti, heavily. Which means that, and it doesn't look like old graffiti all over it. So that means people regularly go on there. And it can't move. It's decrepit. It is by no account being used. She said, well, I haven't been there. I don't know when I was last on it. But walking on it doesn't mean use. It's not a boat anymore. I think any objective view of it can say that it's not a watercraft within the meaning of the statute. There's no reason anybody would think that that is a vessel that's owned, that a person can actually talk to anybody about. If she admitted herself, the creek is not on her property. So there's no reason anybody would know that object in the water required any permission. And that's relevant to the analysis of the statutes. Mr. Deliski testified, I submit very credibly, that he didn't see the sign. This is a case where if we are to find him guilty of any of these offenses, we lose the meaning of New Jersey's trespass statutes. The statutes just become a private right of action. This is not a civil case. This is a criminal charge. And obviously, Judge, for the defined trespass under state law, it is... Actually, Judge, one moment. I would note that on the original complaint charged in this case, for the 2C, for the criminal code, the actual charge indicates it was an abandoned 110-foot yacht. That's in the actual complaint summons. So for them to now claim it wasn't abandoned, I think they can't even do that because this charging instrument states it was abandoned. So I would ask the court to note that, and I believe that's the charging instrument that she signed. So she signed that it was abandoned, but now she's saying it's not abandoned. And that's on the charging instrument. That does not mean evidence. So, again, Judge, I don't know what her actual motivation is to prosecute this case. And whether it has anything to do with the boat itself. But this is not the kind of trespass to property. This brief crisscross across a swamp, or docking on a pontoon landing that's not even on her property, where we're going to find somebody guilty of violating these ordinances, especially under the case law. I'm just going to make sure my client doesn't want me to point anything else out. Judge, I will leave you with this. There were steps that she could have taken to properly secure this property. We saw that with the signage that were put up subsequently. It is not reasonable to allow one sign, that is not even on the dock, mind you. That yellow sign is way back where on the seawall. The seawall that is collapsed. And you can see it in the video and the pictures, it's collapsed. So, you know, when you look at the seawall, it doesn't look like it's part of any currently used property. The first building you saw was boarded up. The sign is not on the dock, the original sign. So, again, there are steps she could have taken, so that, which she has now taken, which would have changed the whole nature of the case. But that's not what happened. And we have to look at the facts in front of us. And again, I submit, it doesn't matter what's on the front. It doesn't matter there's a fence in the front. He couldn't have seen it. And he acted in good faith. Based on, with the same reasoning that the court in Pierce had, which is most people have no objection to strangers trampling through woodland or pasture. That's what this case is. A guy who wanted to see a boat that was on a public piece of water that looked like it had been abandoned, that she signed was abandoned, but now won't say it was abandoned. And in doing so, he crisscrossed what's essentially, Judge, swamp or marsh, or depends on the time. That's not a trespass within the meaning of any of our laws. Thank you.
Mr. President?
Thanks. Just to step backwards to start at the end. In the complaint for the 2C violation, it refers to that, quote, the defendant then walked on my private property to the Blue Jacket yacht, which he then boarded and explored. Referring to the abandoned, that is, if you notice it, it's in quotation marks with the title, Urban Kayaking Adventure Exploring an Abandoned 110-foot Yacht Stuck in a Creek, end quote. That is the name of the video that we had just watched. Okay. Defiant trespass, 2C:18-3B2. Knowing he's not licensed or privileged concerning intent. He knew he didn't belong there. Defendant reacted, he heard the truck, he hid his kayak, he entered onto the place knowingly full well what was going on. Notice against trespass, there has to be notice, he knew it. He knew it because on the other side of the river he had asked permission. This one he didn't ask for permission. He posted. There's a sign, posted. He didn't see it because he didn't want to see it. It's clearly in the video as you're going there. You can see it. It's on the left side. You didn't want to see it. He wasn't even curious to go there and look at it and see, gee, I wonder what the sign says. As far as the date of all this occurring, it did occur. It said on or about November 1st. Exact date, the October 23rd date is with on or about. The fact that other people can trespass is not important. We're talking about this instance. Dock is not on the property, but the land is, so is the boat. Mr. Laurie was never made an expert, and really I didn't see the importance of his testimony. A question was put to Mr. Dolinsky about going on private property. He said, yes, he admitted it. It's private property. He didn't look for the sign. He didn't care. He didn't care for that. The summation, various cases, just quickly responding, State versus Pierce concerns tenants. JSL is an appeal saying that the record did not sufficiently show that the building was not trespassed. Rossier, those were involving county officials coming onto private property. And the Evansville defining vessel must encounter the perils of navigation used for transportation are exposed. This was a vessel. This is a vessel.
It's like a car. If a car doesn't have tires, is it still a car? The specific, besides, Defendant specific law is not involved. Throughout this whole thing, it's called a boat. It's like, looks like a duck, quacks like a duck, must be a duck. It's a boat. The creek is in the property. If you have a pond on your property, it's a pond on your property. The creek is there on the property.
I don't object, Judge. She specifically testified the creek is not a problem.
This is summation, it's not evidential, we can testify on any statement conditions.
Finally, the defense admits to the ordinance 5-13.1. Doesn't matter whether he knew or not. That's what the importance of that ordinance is. It's unlawful to trespass. It basically states, thou shalt not trespass. It is unlawful to commit a trespass on private property. Oxford Language Dictionary says, what is trespass? Enter the owner's land or property without permission. That is what he did, and that is what they've admitted to. He said it twice, both in the summation and the question. Did you know it was private property? Yeah, it was private property. So he did it. And those acts enumerated is 2A and 2D. It's a vessel, watercraft, the boat. You don't belong there. Enter the premises in fact, that was posted. Therefore, Your Honor, you should be found guilty on all 4 counts. Thank you, Your Honor.
Having before me the case of State versus Matthew Dolitsky. There are 4 charges, one 2C18-3B, which is a disorderly persons offense, and there are 3 ordinance violations from the Sayreville ordinance. I find, as a matter of fact, the following. Heard the testimony from Kristen Kabawi. She is the property owner because she has a company called Viking Marine Terminal. It's a company that she inherited, which owns property, approximately 60 acres of property located here in Sayreville, and apparently is fronted on Journey Mill Road. The property that she speaks of, which she is in ownership of, and which she's brought this case on behalf of, is approximately 60 acres of industrial property, which is apparently appears to be some salvage or parking or a number of different things with regard to where people put things on there. It is bordered on several different areas. One on one side, the South River. On the front of it is a Journey Mill Road and is fenced with a gate so that the only access to the property is by a gate. So that entrance would be there only by that means in which you could control access to the property. The idea of all that is to have an expectation of privacy so that it is fenced and gated. Unusual for somebody to enter the property through the river side of it, or over railroad tracks, or over through trees or so on. So the expectation is for privacy in this industrial yard. She testified that she became aware that there was an issue that Mr. Dolitsky came onto the property because one of the tenants provided to her noticed that there was a video that Mr. Dolitsky had downloaded onto YouTube, referred to as his 2 feet outdoors video of him coming onto the property because he wanted to explore a boat that had been on the property which he deemed or thought to be abandoned, and he thought it would be an adventure. He has a business which he refers to as his YouTube business, which is employed. He's had past history with regard to it as being in law enforcement and familiar with just the laws of the various states and doing what you've been doing. I guess he's trying to duplicate, I guess Josh Gates does it by a video that he has on a channel called Expedition Unknown. And he seems to show these adventures with regard to it, such as looking for Bigfoot and other things like that, and he'd go through this whole thing. But he's always touching base with somebody that's on the property or getting the consultants with regard to it. On this particular occasion, on October 30th, 2024, Mr. Dolitsky apparently got permission from the South River Boating Club to enter onto the South River so that he'd have access to paddle down on a kayak to this property owned by Viking Marine Terminal. In doing so, he wanted to take a look, and I guess do a duplicate of Expedition Unknown, never asking for permission to get onto the property, never contacting the owners of the property, and knew it wasn't public land. His intention thinks that it's an abandoned ship and he's going to report for it of what newsworthy issue it is or anything normal or unnormal about it. Doesn't mention with regard to it except that he's going to put content which he apparently seeks subscribers for on his YouTube video. He'd been wanting to do this for a long time, so he had certainly plenty of time in which to contact the owner of the property to see what it was about, and maybe even question as to what this vehicle or vessel, boat, was there, and why it was there, and what happened with regard to it. So we wanted a history. Why would he contact the owner of the property to find out? To do that, he, of course, would have had to go to the place, adjourn the road, go through the gate, because it's fenced in and he wouldn't be able to obtain or view. He could certainly ask for permission with regard to it, but he chose not to do that. Clearly, this was private property. It's bordered on different ways in which you couldn't get to it, but it's fenced in. In front of the fences, with regard to it, are signs that said no trespassing. A number of them. Been testified to by Ms. Courtroom. Mr. Dolitsky then goes through trying to go up the creek with regard to it. Couldn't do that because the elevation in the water was too shallow, and so had to return back. He went to the dock that's on the property. The question is, it was not heard on her property. No, that's true. It's attached to the property, and it's a dock. And what was noticeable by me was that there was a sign that you immediately saw in the video, a yellow sign that we now know was faded, says no trespassing, no wake. But that there was a sign that wasn't supposedly noticed or reviewed by Mr. Dolitsky. Clearly, this is private property. And to go see this video, this boat, and a lot has been said, is it a boat, is it a vessel, whatever it is. Clearly it's a boat. It's built as a boat. Is it operable? No. Is that the main part of that? There is a boat with regard to it? I suspect people are thinking that it's an operable boat and that people, instead of just going into a house, can also go into a boat. And so I guess that's what it was about. But this is a case about trespass. Mr. Dolitsky wanted us to get to see that boat, and to do so couldn't go up the creek and then enter onto property that he wasn't privileged or licensed to do so. That's what the case is about. We've heard about the sign, no wake, from Mr. Lorray. Is he an expert as to signs or no wake? No wake is an issue with regard to it. No trespass is, the sign did have no trespass. But it was more than that. It's a property that has expectations of privacy. It's fenced with a gate. And he wanted to take a look at a piece of an item that was on the property, a boat that's gotten into bad shape with regard to it. Is it abandoned? No, she hasn't abandoned it, it's just on her property. Is it usable? Never was. You heard testimony that the property, that the creek wasn't navigable, that it had mud. You understand that? He said there were no signs. There is a sign, but the signs were on the front of the property where anybody who had an expectation to come onto the property would have seen. So then he goes into a side entrance where there's not a sign on that. That makes it okay? I don't think so. The boat wasn't accessible. I guess it becomes an attractive nuisance after a period of time, now that everybody's seen it and would want to see what an old boat would look like. Guess it would cause more people to go there. You'd have to put up more signs because now that there's a video showing that there's a boat on the property, and it has certain character because it's an old boat. But it's really a simple case. It's trespass. C 18-3 talks about unlicensed entry of structures defined trespass. Person commits of any disorderly person's offense if knowing that he has no license or privilege to do so. Did he have a license to go on the property? No. Did he have privilege? No, he never asked for it. Do the people who have the property expect privacy? And nobody trespassing on the property? Yeah, they put up a gate, they put up fencing. They put up signs. And it'd be easy to cure all this if he just contacted the owner of the property. Walked through the gate, asked to speak to somebody to see what the property was about. He didn't have to go by kayak. Could have walked over to the property, could have asked permission to do so. He chose not to do that. Why? Does that make the video more exciting or whatever it is? That's what he chose. The question is, was he get on the boat? Well, he was on the land. He was on private property. That's where the trespassing stems from. Notice against trespass is actual communication. Well, they didn't speak to him because he didn't come onto the property the way that it would normally be expected. But it is posted in a manner prescribed by law. Reasonably likely to come to the attention of intruders. Somebody who would come to the property and go through the front gate and go through an area that's fenced off and that you would ask for permission. And it's been fenced, manifestly designed to exclude intruders. Because Mr. Dolinsky wants to showcase or do something that he would like to do for his video, does that give him permission to go ahead and do something because it's of public interest? I don't think so. I find the credibility of this court Bowie to be straightforward. She didn't lie or hesitate with regard to it. The question that came up is ownership. And is it in her name? No, it was not in her name. It wasn't ever in her name. It's named a company that she has control and ownership of. Is it her property? Sure, it's her property. Could she have been asked to allow to come onto the property? Could have. She wanted to give permission or privilege to do so. There are signs throughout the property just because it wasn't in a particular location near the boat that Mr. Dolinsky wanted to take a look. A lot has been said about this no wake, no trespass sign. Yes, it is faded. There is a sign, there's a sign that you can see coming in with regard to it. The video you can't see with regard to it because it's too small and the camera isn't focused on the sign. It's certainly right there. Is it far away? No, it's right at the dock. It's on the land portion, not on the dock, so the dock comes through. A lot has been said that she doesn't own the dock. Well, she owns the dock. It's attached. Is it on her land? It's on the water, but it's attached and physically attached to the dock and to the seawall. There are a number of things with regard to it that Mr. Dolitsky seems to have been aware of. He wanted to hide, he didn't say to secure it in another manner, he wanted to hide his boat so that nobody would see it, nobody would know that he was there. Then when he leaves, he said, oh great, we're all clear. He's had words of, well, I just wanted to make sure nobody stole my boat. He tried to hide that he was there, tried not to show anybody that he was there, make sure that nobody was around to see it. And it was with purpose and intent, so that nobody would know that he was there. He then got onto the property, walked through to get to the boat. It wasn't as if he was in the water watching from afar. He went onto the boat, which was on the property. This boat wasn't being moved. It hasn't been moved in years. A lot has been said as to no wake signs and things like that. Clear that there wasn't an expectation. There's an expectation of privacy. Mr. Dolitsky didn't want to do that. He did it his way. He was going around because he was going to have an adventure because that's what he does. Does it mean it's right? No. Taken to the facts that he was on the property, clearly walking across the property, having to walk across the property to get to the boat, to get into the boat, to go on property that he wasn't privileged or licensed to do so. It's a simple proposition, although we've heard testimony in every other area. Applying the facts to the law 2C18-3, clearly, beyond reasonable doubt, I find Mr. Dolitsky guilty of the charge of trespass. With regard to the Borough Ordinance 5-13.1, unlawful to trespass, it should be unlawful for any person to commit a trespass within this borough upon either public or private property. Did he do that? Yes. Facts are clear. That was his intent, to go across the property to get to it. Maybe he wasn't originally, maybe the thought was he was going to try to just go take a look at the creek, but he couldn't do that, so then he had to go onto the land and do things with regard to it without permission. The ordinance of 5-13.2, acts of trespassing enumerated. So it tells you about the different things with regard to it that are specifically speaking to it, which was addressed as A and D. The fact is that he violated the Borough Ordinance of 5-13.1, unlawful to trespass. They define it with regard to the different acts with regard to it so that everybody's clear that there are different acts with regard to it. Is it another violation or is it just one violation? I find that it's one violation. It was unlawful to trespass, and accordingly, applying the facts to the law, I find you guilty of unlawful trespass under the Borough Ordinance. The others are the same thing, it's just duplication with regard to it to list the acts, but it's the same thing with regard to it. But it's an act of trespass. So I find you guilty of the one and merging the other, which I gather is the major issue that Mr. Uriel wanted to mention. Is it a boat? Is it not a boat? Is it abandoned? It's an act of trespass. One act of trespass. Accordingly, I find you guilty of those charges. Statement you heard on sentencing.
The complainant wishes to make a statement, Your Honor.
Go ahead.
Thank you very much, Your Honor.
Absolutely.
Yes, of course.
I appreciate your ruling today, and I would just like to add, as Your Honor has deduced, that our property, Viking Terminal, is not a playground for people to explore. It is industrial property and a private property where small businesses store their trucks, tools, and equipment. Our tenants and ourselves as the property owners gratefully expect that the only people who enter the property do so for legitimate business purposes and not like Mr. Delitsky for criminal mischief. One of the reasons we take trespassing so seriously is that videos like Mr. Delitsky's draw attention to our property and result in copycat trespassers. We've had multiple copycat trespassers since Mr. Delitsky started posting his videos about the boat, our property, and me. The most recent occurrence was this past Saturday night when a group of 6 teenagers explored the property looking for the boat. Thankfully, they were apprehended by the Sayreville police. Something lost in Mr. Delitsky's self-promotion of this matter is that I am the victim in this trespassing case, and I have continuously been victimized by Mr. Delitsky. Last year, he posted a video with my work email and phone number, and thereafter I received numerous emails and voicemails from his followers using disgusting and vile language and even threatening me and the property. And they left similar comments on various social media platforms. It seems that none of these cyberbullies recognized that it was Mr. Delitsky who broke the law, and not me. Importantly, Mr. Delitsky also profited from the November 13th, 2024 trespassing video and subsequent videos through the advertising revenue on his YouTube channel. In other words, he profited off my privacy by breaking the law. He has never shown remorse, and he's never offered to take the first video or any of the subsequent videos down. And he's continued to profit from it by posting those additional videos, again, about the boat, the property, and me. But unlike the trespasser or the teenagers who trespassed a few days ago, Mr. Delitsky is a middle-aged man, and he should know better than to snoop around somebody's private property for entertainment, especially a man like Mr. Delitsky with his professional background and training as a police officer. Therefore, I respectfully request that the court consider these factors in sentencing Mr. Delitsky.
Yeah, on a few things, Judge. I want to start with this idea of his followers. Mr. Delitsky is not a cult leader. And I understand, regardless of our strong disagreement with the court, especially on the defiant trespass, I understand that there was a lot of difficulty that results from having this boat on our property and various people going on there. Some possibly do this video from the graffiti. I will submit that, it seems as though all of the blame for everybody going on this property, everybody making phone calls, people he never asked to make phone calls. This was publicized in multiple newspapers, not just on his channel. So that's the most emotive thing, and obviously it's wrong for anybody to call her and say anything to her or threaten her or anything like that or harass her. That's wrong. But that doesn't go on him when we're talking about sentencing for a person who was convicted of going onto a property and doing so in violation of a sign that, by the court's own findings, he didn't notice, or he didn't care to notice. It was the court's, I believe, decision. But fundamentally, this is a case where the absolute minimum fine should be imposed. Because fundamentally, regardless of the consequences, none of that was his intention. He's an outdoorsy nature person who wanted to share his love of water. He's a kayaker. He kayaks all the time. It's easy to say, well, why didn't he go down the road? Because that's not where he was going. He was kayaking. He's a kayaker. He told you he didn't really understand where the property lines were. This was a very large property. Now, I understand the court's position, but when we're talking about sentencing, to take all those things and to put on him is, and again, I submit there's no reason to suspect that his followers did anything. This was pretty well publicized. But it's irrelevant. The court mentioned that a lot of the testimony was irrelevant. I don't think it was. I don't think it was, because we're talking about signage and defiant trespass and reasonableness of him seeing it. So I think this is all very relevant to those questions of reasonableness. But no, Judge, I'm making a point about sentencing, Judge. We have to look at what actually occurred when deciding what an appropriate sentence is. And fundamentally, this was not egregious behavior. This was not someone entering someone's home or somebody who was entering for some nefarious purpose. This is somebody who wanted to make an entertaining video. And whether he did it in the wrong way is obviously the issue. But everything else that flowed from that isn't on him, and it's not fair to put that on him. So I would ask the court for the absolute minimum sentence here, in light of the actual conduct that occurred. Which again, I'm not minimizing the conduct. I am arguing, Judge, that it doesn't warrant anything more than a minimum sentence. This is not a person with a record. This is somebody who comes before the court, a law-abiding citizen, retired, who just wanted to make a video. And obviously it got away from him.
One of the first things I said was that, watching this video, you think it's become an attractive nuisance, that people are gonna go to this boat now. They're gonna go wanna see what they saw. They wanna go see that there's something out there. It's one of the first thoughts that I had. This isn't a terrible case. I understand what he was seeking to do, just did it wrong. But did it wrong for wrong reasons and everything else, but it could have been cured so simply. And I think the statement made by Ms. Carvalli is accurate, and what would have happened as a result of this happening. To be a fine of $407, $33 in court costs, $50 to the Violent Crime Commission Board, $75 to the Safe Neighborhood Fund with regard to the criminal charge for 2C. I'm also giving you a defined trespass notice. Even though there are signs up there with regard to it, you're being given a defined trespass notice. You are not welcome to go to that property or go near that property, boat, or anything else with regard to it. If you do, you'll be subjected to a criminal charge of trespass again. With regard to the ordinance, it will be a $400 fine, $33 in court costs. Mr. Delitsky, you have 20 days from today's date to appeal. It's a rather complicated process to appeal. You have to file a notice of appeal, request transcripts, pay filing fees to perfect your appeal. I suggest it would behoove you to have an attorney to file your appeal, and you have one presently. I just want to make some other key things with regard to it. I did review the cases that are mentioned with regard to, and I don't find them to be apropos to this case. They're all different with regard to it. This is a case about trespass. That's all it's about. All these other things with regard to it, it's superfluous or red herrings.
If I may, Your Honor, we'd also like to request that Mr. Linsky be ordered to take down all videos referring to this matter.
Judge, I think there's some serious First Amendment issues with that request. It's not within the scope of appropriate punishment. It's not within the scope of any, I don't believe it's within the court's authority to take down a video of this nature. I think that there's some serious concerns about, overreach in a case like this. And again, he learned about the boat from a different YouTube video. I mean, I also know, since the court pointed out the case law, perhaps I wasn't clear about why I view it as relevant. In a case where somebody went into an actual building with a sign on there, on the building, the court found that that wasn't sufficient. And I was trying to make the analogy that here where there is no building, and the sign was not on the actual entrance, that, the court's reasoning is analogous.
I made my decision.
Understood. But as for the video, Judge, I was sort of
I placed it on the record in the appeal. If you don't wish my decision with regard to it, I'm not going to re-argue the case, and I'm not going to re-argue the things with regard to it. Decision is made on one side to the violation, minimum, take care of the fines there. That concludes the count.
Was there a decision on the video, Judge?
A video?
Yes, that was my request, that you be
Oh,
ordered
no.
to.
Sometimes people ask me where I had, I don't know. I can't do that. It's already in the internet. It's already online. I'm not going to be able to enforce something like that or do anything else with regard to it. I think it's an issue with regard to it because if there comes people and things happen. Scorbata may have a civil case with regard to it because of the dissemination of it and people come to a place. That's nothing that I can deal with and everything else now, but I don't have the power to take that down from the video. Since it's already out there and it's been out there since 2024. So, and sometimes people ask me where I had, I don't know. I'm not in a position to do that.
Thank you, Your Honor.